this is very valuable because you have given us the complete legislative.
My lord, I'm grateful to you, lord.
One level,
My lord.
all this has been regulated by statute.
My lord.
Right from 1956.
My lord.
The nature of the regulation has been by statute.
My lord.
The only point is this: absent an enabling provision in the statute, namely the Companies Act, no company can donate for political purposes at all.
Yes.
Right?
Yes.
So though at a certain level or at first blush, this is regulated by statute.
My
what
lord.
is conferred by statute can be taken away by statute. All right? No implication of a fundamental right can arise. So for instance, just wait a minute.
My lord, my lord.
It may not be against you.
Yes, no, I'm not.
Suppose there was no provision in the 1956 Act at all for political contribution. What would be the consequence? Consequence is not that companies are free to donate for political purposes untrammeled by any other provision. The 1956 Act, for the first time, when that enabling provision came, provided, in fact, initially there was a complete ban. 1960 was 5% of the net profits or 20,000 rupees.
My lord.
Absent that provision, you could not have contributed at all.
My lord.
Then comes the ban in 1969. Ban is lifted in 1985. So though it is a matter of statutory regulation, absent an enabling provision, a company cannot contribute to political purposes.
My lord.
So if the constraints subject to which those contributions are permissible are lifted by the legislature,
my lord,
they are amenable to be tested under Article 14.
Article 14. Yes, my lord. And it is manifestly arbitrary, my lord. There are two reasons which are given.
So it's not just a question of what the legislature enacts, it can take away. There's no fundamental
it is not like that, my lord.
But when you are making an enabling provision for contributions,
my lord,
and taking away the restraints on companies,
the
taking away of those restraints is amenable to be tested.
Is amenable to be tested on manifest arbitrariness, my lord. Because, my lord, there are two objects which are given. To give transparency, I'll show to your lordship that only two objects which are given, my lord, for amending this.
No, my lord. I mean, transparency and other things you cannot repeat because that your predecessors all argued.
Very well. So it is amenable to be tested.
But this is very valuable because you have given us the complete list.
My lord, I'm grateful to you, lord.
Now, what do we from here?
Now, would your lordship see similar changes in the Income Tax Act?
All right, let's see the Income Tax.
Yes, my lord. Which are in, my lord, page 12 of my same compilation.
Well,
heading of page 13, exemption will not be allowed unless the political parties maintains proper books of account, records the name and addresses of every person who has made voluntary contribution of more than 10,000.
You're reading the statement.
I'm reading the statement of diligence. Then I'll come to the section. And accounts political audited by the chartered account. Now, lordship has seen yesterday, Mr. My London friend Parasa said, one DV, KV has given 1 lakh and that is exempted, my lord, without details. My lord, my submission would be, my lord, when it comes to the scrutiny of the political party's income, my lord, nobody applies its mind. The income tax officer should have said, my lord, you are required to disclose details. Accept cash of 1 kV, my lord, of 1 lakh rupees. Page 5553, my learned friend Mr. Farah showed that, my lord, to your lordships. And that is accepted. 2003 as the large number of changes in the Income Tax Act, my lord. And the Electoral Bond Trust, my lord, I'll invite your lordship's attention as it came, my lord. It was introduced. To keep the identity of the donor, my lord, which is being said corporate houses to be secret, my lord, not to go in public domain, etc. The purpose of one of these things is said that has been taken care of by Electoral Trust. In 2003 amendment, my lord.
Let's read this para 10, which sums up what happened.
Yes, my lord. Para 10.
So till 2003, there was no equivalent of 80 GGB and 80 GGC.
Please, your lordships.
So at that time, therefore, these donations will not be covered by Section 37 of the Income Tax Act.
Yes, my lord. No, Section
37 is the expenditure clause.
Lord,
they will not be covered. It's not wholly.
The donor will not get, my lord, the exemption.
Donor will not get the exemption.
Yes, the political party is receiving, my lord.
They are exempt.
Their income is exempted provided those conditions are met.
Satisfied.
But the donor will not get it.
It was not treated as expenditure in the hands of the donor.
Please, your lordship. And 80 GGB and 80 GGC. Would your lordship see this section, lord? It's not available on record, my lord. I have given the
All right,
books.
who upload karo 80 GB or 80
Yes, I have
GB.
given in the one. Wait to politician. Who? Isme hai? No, we have given the list. Anyway, it doesn't matter. My lord, may I just read the summary of it, my lord, and in the meantime. Yes, my lord, may I read pattern? Made the following major amendment. 80 GGB and 80 GGC was inserted to provide that, I'm so sorry. So, my lord, in 2003,
Three.
exemptions are given to the donors also, my lord.
Right.
So we can donate any amount of money, exemption, my lord. Now comes, my lord, 2009,
Yeah.
that the scheme of electoral trust is introduced, my lord, by inserting section 13B. So may I just explain the scheme, my lord? So 5 companies can create an electoral trust. You make the company makes a contribution to the electoral trust. It reflects that I have made a contribution to the electoral trust. My lord, those pages are here, my lord, unfortunately in here, to a electoral trust. The company's account will show that only. And my lord, and the electoral trust must make 95% of its contribution to the political parties. It gets, my lord, deductions completely. So through that route, my lord, companies can make donation to the political parties.
Yes.
And 80 GGB and 80 GGC is also amended in 2009 to show, my lord, that any donor to the electoral trust also gets an exemption. And lordship may only make a note, my lord, Rule 17CA of the income tax rules, my lord, makes the detailed provisions about how to electoral trust is to be function, my lord, maintain, etc. account details. So the scheme is, my lord, in 2009, you make an electoral trust, company make donation to the electoral trust, you get an exemption.
5 companies could set up an electoral trust.
That exactly has happened, my lord.
And was there any restraint on how the electoral trust should contribute to a political party, or they could contribute to any
electoral
political
trust,
party?
but it has to mandatorily contribute 95%.
But was there a requirement of disclosure, maintaining accounts, etc.?
That is there in the rules, my lord, in 17CA.
Rule?
Rule 17CA of the income tax rules changed in 2013. The complete thing is made in
No,
2000.
this provision was incorporated in 2000, was enacted in 2009.
Yes.
So the rules must have been made at that time itself.
Or they came at the first time?
I'm sorry, my lord, I couldn't get.
The rules must have come in at that time itself. Was there any restriction as to the quantum of donation which should be given to a particular political party? Was it restricted on the basis of the electoral
No,
share?
basically, idea was, my lord, the corporate identity
share?
may not be disclosed.
No, that's fine.
So this is the route.
Now, for the outgo, was there any restriction as to whom it should be across the board, or it was restricted only, it was complete? You had the option to go to give it to any political party.
Electoral trust, my lord, has to be, my lord, the formulation has to be approved by the income tax commissioner, etc. Rules have said.
No, but the point is,
Yes,
would
ma'am.
an electoral trust say that we are going to give money only to one political party?
Yes.
Or was there, let us see that rule. You
Yes,
said
ma'am.
rule 17CA,
It can
Rule
be given to
17.
one party also.
one party also.
That I have the,
No, there was no restriction.
there was no restriction. Instead of 5 people differently donating,
They all
create
gave
a
it to an
trust.
electoral trust.
There are some 28 trusts and that scheme still continues.
Right.
But
Yes.
it was found to be a non-starter.
It was that we
I'll
come
show
to
the
that,
figures.
but there was no restriction that you had to equally distribute
No.
or proportionately distribute.
No.
Between them.
Like-minded people can come together, create a trust and donate to one party.
17CA.
I don't know, I got some impression that probably there was some proportion.
I can.
Let's
No,
check it up.
we have the figures on record. I'll show to your lordship.
No.
Electoral trust figures are on record.
Collectively, they may have given to different parties, but there was no rule,
No
prohibition or embargo
All right.
that they have to equally distribute.
No.
They can give to one party.
Let's see that rule 17ACA,
Sib-
because 13B, subclause B says, such electoral trust functions in accordance with the rules made by
My
the
lord,
central government.
that's the rule 17CA.
Now let's see what that rule says.
Yes, my lord.
Rule 17CA upload kar dijiye zara.
Nahi, I think. Rules are not there, my lord. They're not online. You have it online? Can you share it? We have it online. Link. Is it?
Yeah, give the link to him, he'll do it. Share.
Can share?
Sanjay?
Can we share it?
But
आप आपको लैपटॉप दे सकते?
I can adopt that.
Can we mail to your lordships that ID, my lord? Huh? Mail.
Mail it to the court master. No problem.
Yes, mail it to court.
Oh, that it said the electoral trust shall not accept any money from, I just missed it here, from any foreign entity, whether incorporated
Yes,
or not.
yes. So foreign entities come now, my lord. I'll show to your lordship, presuming the FCRA regulation is valid. Even in defense sector, my lord, they can pump any amount of money, defense companies. If your lordship see, my lord, 1 to 6, who said, who electoral trust can accept money from whom?
थोड़ा scroll कर लीजिए नीचे.
7 is possibly answering your lordship's questions.
7 दिखना, हाँ, थोड़ा सा ऊपर जाइए बस. नहीं ऊपर और. Political party. रुक जाइए.
Only to eligible political parties.
And
29
7.
Spend up to 5% of its total contribution.
No, because 95% you have to contribute. 5% only you can keep. 7 is important and 8 is important. First, lordship may permit me to read 7.
Just read 7.
Yes, my lord. A political party registered under section 29 capital A of the RP Act shall be an eligible political party, and electoral trust shall distribute funds only to the eligible political parties. So, my lord, you can distribute, my lord, to whichever political party, but registered under 29A. I'll come to the scheme of RP Act. 8. Electoral trust may, for the purpose of managing its affairs, spend up to 5% of the distributions received in a year, subject to an aggregate limit of 500. In the first year of incorporation, rupees 300,000 in the subsequent years.
Fact that in the Election Commission of India, then issued a directive. They issued a directive after this rule was brought into force,
My lord.
mandating a disclosure by political parties of contributions which were made.
My lord.
Once the Election Commission of India mandated an exercise of its powers under Article 324
Yes.
that there should be a disclosure,
Yes.
then this became a non-starter because then you had to come up into the public realm
Yes.
on what you have donated.